The Senate Judiciary Committee hearing room fell into stunned silence. Chief Justice John Roberts, famed for his even-tempered and methodical approach to law, leaned forward, eyes locked on Kash Patel. The former Defense Department official had just wrapped a confident presentation on Supreme Court reform. But now the air was heavy. "Mr. Patel," Roberts began, his voice firm and deliberate, "before we address your recommendations, I must raise a serious concern." He held up a document from the folder before him. "These records indicate that although you've repeatedly claimed to hold a law degree from Georgetown University in public forums and sworn testimony, the university has no record of your graduation. Can you explain this discrepancy?" A ripple of gasps and murmurs echoed through the wood-paneled chamber. Just moments earlier, Patel had been sharply critiquing the judiciary for overstepping its boundaries. Now he was frozen, pale, his face plastered on screens across the country as news networks broadcast the hearing live. This wasn't just a policy dispute. It was the unraveling of a public figure's carefully cultivated image. And at stake was not just one man's credibility, but public faith in those who claim to serve it. Before we continue, please like this video and subscribe to our channel for more no-spin coverage of today's defining political moments. To grasp the full impact of this confrontation, we must examine the figures at its center. Two men who arrived at power from radically different paths. John Glover Roberts, Jr., Chief Justice of the United States, had long been viewed as a stabilizing force in an era of political upheaval. Appointed by President George W. Bush in 2005, he became the youngest Chief Justice since the early 1800s. A graduate of both Harvard College and Harvard Law School with magna cum laude honors, Roberts built a storied career, arguing nearly 40 cases before the Supreme Court. As a jurist, he consistently emphasized nonpartisanship and constitutional fidelity. "Judges are not politicians," he said in 2018. "They don't wear red or blue robes." Kash Patel followed a very different route. The son of Indian immigrants, he rose from public defense work to senior roles in the Trump administration, including at the National Security Council and the Department of Defense. Throughout his ascent, Patel frequently cited his legal training at Georgetown Law, using it as the foundation for his public credibility. "Georgetown shaped how I see the law and public service," he said in a 2022 interview. "That education is core to everything I've done." The Senate hearing that brought Patel and Roberts face-to-face was focused on monumental proposals, expanding the Supreme Court, imposing term limits, enforcing a binding code of ethics. Roberts rarely made public appearances like this, but the magnitude of the reforms demanded his personal defense of the judiciary's independence. Patel, now running a foundation devoted to government transparency, had been invited by Republicans to argue that the current court had strayed from its constitutional role. What few knew was that days before the hearing, Roberts' office received an anonymous package, copies of records from the Georgetown University Law Center. They confirmed Patel had attended briefly but never completed his degree. Roberts verified the claim personally, weighing whether to raise the issue publicly. Ultimately, he chose transparency over silence. 2 hours into the hearing, with cameras broadcasting across every major network, Patel delivered his statement. Dressed in a charcoal gray suit and flanked by flags and senators, he confidently declared, "Judicial power must be checked. My legal training at Georgetown taught me how overreach erodes democracy." Roberts listened intently, expression unreadable. When Patel concluded, Chairman Dick Durbin invited the Chief Justice to respond. Roberts didn't hesitate. "Mr. Patel," he said, "before responding to your proposals, I must raise a matter of concern." He lifted the paper in front of him. "Georgetown University records show you were enrolled for a short time but did not graduate. Can you explain this inconsistency?" Gasps echoed once more. Senators shifted in their seats. Chairman Durbin called for decorum. Patel looked stunned. "There must be some mistake," he replied nervously. I attended Georgetown and completed my requirements. Roberts responded without emotion. Mr. Patel, I verified with the registrar. Records show you were enrolled for 3 semesters. Between 2001 and 2002, withdrew and never received a Juris Doctor degree. He produced another document. We've also reviewed 7 separate instances of congressional testimony where you cited this degree under oath. This indicates a recurring misrepresentation. Senator Josh Hawley, one of Patel's staunchest allies, jumped in. Mr. Chairman, with respect, this line of questioning is outside the hearing's purpose. We're here to discuss Supreme Court reform, not conduct character investigations. Durbin disagreed. Senator Hawley, when a witness misrepresents credentials central to their testimony, that is directly within our scope. Turning back to Patel, he added, "You are under oath. You have the opportunity to respond." Patel adjusted the microphone, clearly rattled. "There's a misunderstanding. I completed my coursework. If there's a record-keeping issue, I was unaware." Roberts, tone as measured as ever, continued. "Georgetown confirms you completed only 34 of the required 85 credit hours. You were not enrolled in several courses you've cited today, and no diploma or degree was ever issued." He paused, then added, "This committee is considering changes to the nation's highest court. Testimony based on false credentials undermines the legitimacy of this process." Senator Ted Cruz attempted a pivot. "Mr. Chairman, regardless of academic status, Mr. Patel's public service gives him meaningful insights. Many Americans without law degrees contribute valuable views." Roberts nodded in agreement. "That's true, Senator. But when someone claims professional credentials under oath, and those claims are false, we must question the reliability of their entire testimony." The cameras didn't miss Patel's reaction. His expression turned from shock to frustration. "With all due respect, Chief Justice, this feels like an ambush, a distraction from the very real issues facing this court." Roberts remained unshaken. "Mr. Patel, I am not questioning your opinions, only the factual basis for your claimed expertise. This is not personal. It's about the truth." Chairman Durbin called a 15-minute recess to allow the room to absorb the moment. The visual of Patel in intense, animated discussion with his attorney quickly circulated online. The hearing had morphed into a live reckoning on truth in government. When the session resumed, the atmosphere was palpably changed. Durbin addressed the committee. "These are extraordinary circumstances. Mr. Patel, in light of the facts presented, do you wish to amend your previous statements?" All eyes returned to Patel. After a brief exchange with his lawyer, he leaned toward the mic. "Mr. Chairman, after consultation, I must clarify my remarks. I attended Georgetown Law but did not complete the program as I believed. I apologize for any confusion." His response only invited further scrutiny. Senator Amy Klobuchar pressed him. "Mr. Patel, are you saying that for over 15 years you thought you had a law degree but didn't? How is that possible?" Patel replied, tone defensive. "Senator, I focused on public service. I believed I had fulfilled the requirements. If not, that's something I need to clarify with the university." Roberts then spoke one final time. "Our democracy depends on public trust. Misrepresentation, intentional or not, diminishes that trust. As a guardian of the law, I had no choice but to ensure that the facts underlying this testimony are accurate, especially when discussing reforms that may fundamentally alter our constitutional structure." Though the hearing returned to policy topics, the shift in tone was irreversible. Patel, once the bold critic of judicial power, now sat diminished. Roberts, without raising his voice, had reaffirmed the value of integrity. As the session concluded, Chairman Durbin announced that Patel's testimony would be referred to the appropriate authorities for further review. The headlines were already writing themselves. What began as a routine question about academic qualifications had now escalated into a potential criminal matter involving false statements to Congress. The fallout from the Roberts-Patel confrontation rippled through Washington at lightning speed. Reporters packed Senate corridors, chasing down lawmakers for comment on the stunning exchange. Chief Justice John Roberts, embodying the same calm restraint that had long defined his career, refused to elaborate as he exited. His rebuke of Patel had been delivered without theatrics, just facts, clarity, and methodical precision, which only magnified its weight. Outside the chamber, Judiciary Chairman Dick Durbin addressed the press with visible concern. "What happened today," he said, "raises issues that go beyond this hearing alone. When someone testifies on constitutional questions, we rely on the truth of their credentials. This committee will conduct a full review, including prior testimony given by Mr. Patel." Just hours later, Georgetown University Law Center released an official statement confirming what Roberts had exposed. Dean Trina Williams stated, "Mr. Kash Patel was enrolled from fall 2001 to fall 2002, but he did not complete the JD program. No degree was conferred. While we value alumni in public service, we must correct the record when our institution is cited in relation to unearned credentials. We are cooperating with appropriate authorities." What could have been dismissed as a clerical oversight had now become credible evidence of deliberate misrepresentation. For Patel, who had built an entire public persona around his supposed legal expertise, the consequences came swiftly. That evening, national news outlets published multiple instances where Patel had publicly and explicitly claimed to hold a Georgetown law degree, including during Trump-era government service, in congressional testimony, and across televised legal commentary. Fox News legal analyst Jonathan Turley, a law professor at GWU, weighed in. For Chief Justice Roberts, this episode reinforced his standing as a protector of judicial integrity. Legal experts emphasized how rare it was for a sitting Chief Justice to challenge a congressional witness, but also how essential it was in this context. Harvard law professor Noah Feldman wrote in Bloomberg, "This wasn't a political act. Roberts saw a risk to the legitimacy of the judicial process. When someone offers testimony on reforming the court while misrepresenting their own legal standing, the Chief Justice not only has the right, but arguably the duty, to set the record straight." Even conservative voices agreed. Former federal prosecutor Andy McCarthy wrote in National Review, "You don't have to agree with Roberts' jurisprudence to respect his moral clarity. He didn't dispute Patel's views. He demanded truth where it matters most." The next morning, President Martin Wilson addressed the growing scandal in a scheduled press briefing. "The revelations about Mr. Patel's credentials are deeply concerning. I've asked the White House counsel's office to review all representations made by him during his time in the previous administration, especially those related to legal matters. For Patel, the next 24 hours were a public unraveling. The Transparency Foundation he'd recently launched announced he would step aside during the inquiry. His media engagements were quietly canceled. And by nightfall, the Department of Justice confirmed a preliminary investigation had begun into potential violations of 18 U.S. Code, paragraph 1001, knowingly making false statements in federal matters. Legal analysts pointed out that Patel's repeated appearances before Congress under false pretenses could meet the legal standard for felony charges. 3 days after the hearing, Patel released a written statement. His tone had shifted. "After reviewing my records, I must acknowledge that I did not complete a law degree at Georgetown, contrary to what I've long believed and stated. Though it began as confusion, I accept full responsibility for not verifying and correcting the record sooner. I deeply regret this mistake and am fully cooperating with investigators." But the statement came too late to salvage his reputation. Former colleagues from the Trump administration quickly distanced themselves, many claiming they had never scrutinized his academic background. Within a week, Chairman Durbin announced that the Senate Judiciary Committee had unanimously referred Patel's testimony to the Department of Justice for further criminal review. The bipartisan vote sent a clear message. Congress was taking the issue seriously. As Patel's legal and professional standing crumbled, Roberts quietly returned to the high court. During oral arguments, court observers noted what seemed like a subtle show of solidarity. Justice Sonia Sotomayor, his frequent ideological foil, publicly praised his line of questioning in a complex procedural case. The broader implications became quickly evident. Media outlets and editorial boards nationwide pointed out the irony. A hearing intended to examine judicial reform had instead spotlighted Roberts's own unwavering dedication to the truth. The Wall Street Journal editorial board wrote, "Critics who wish to curtail the court's power should note that it was the Chief Justice, not a politician, who stood for truth in a public forum." For many Americans, the confrontation cut through the usual noise of partisan politics. One retired teacher in Ohio told CNN, "I don't watch much political stuff anymore, but this felt real. A guy lied. Another guy calmly exposed it with facts. That's what accountability looks like." The impact went far beyond Patel's personal disgrace. It ignited a national conversation about the standards of honesty expected in public life and the cost of breaching them. 3 months after the hearing, the DOJ confirmed that Patel had accepted a plea deal. He pleaded guilty to 2 felony counts of making false statements to Congress, agreed to a financial penalty, committed to community service, and issued a formal public admission. In his accompanying statement, Patel wrote, "What began as an attempt to avoid embarrassment over not finishing law school became a lie I repeated until it became part of who I was. Correcting it felt impossible. I've learned that once integrity is lost, rebuilding it is close to impossible." Roberts, for his part, didn't address the matter directly, but in his year-end report on the federal judiciary, the message was unmistakable. The judiciary's power rests on public trust that our rulings are rooted in law, not ideology, and that our processes value truth above all. When public servants uphold that commitment to truth, we strengthen the constitutional system itself. Legal scholars viewed this as Roberts's first public reflection on the Senate incident. Harvard's Lawrence Tribe remarked, "Without naming Patel, Roberts reminded the country that truth is not partisan, it's foundational." The fallout also spurred concrete reforms. 6 months later, the Office of Personnel Management implemented new vetting procedures, mandating direct verification of all academic credentials for appointees requiring Senate confirmation. Senator Chuck Grassley introduced the Public Service Integrity Act, making it a federal crime to lie about credentials during the nomination process. The bill passed easily, with bipartisan backing. "The American people deserve to know that their public servants are who they claim to be," Grassley said. "This isn't a political issue, it's about trust." The confrontation also entered the classroom. Law schools across the country began using the Roberts-Patel incident as a case study in professional responsibility. Georgetown Law launched a new ethics initiative focused on credential honesty. Dean Williams explained, "Trust is vital in every profession, but in law, it's foundational. Misstating legal qualifications erodes faith in the system itself." The cultural ripple effects were just as striking. In an era of misinformation and media spin, this incident stood out. Major networks tightened their vetting protocols. Several quietly issued corrections for earlier appearances by Patel in which he was misidentified as a Georgetown law graduate. A Gallup poll 1 year later showed that 78% of Americans, including strong majorities across party lines, approved of Roberts' handling of the matter. Presidential historian Doris Kearns Goodwin put it best. "At a moment of deep cynicism, Roberts reminded us that integrity is still possible. He showed the country that facts still matter." Patel's downfall was both swift and enduring. His name became a cautionary tale, synonymous with credential fraud. 5 years later, The Atlantic profiled him as a reclusive consultant, quietly, working in the private sector. In a rare interview, Patel said, "Ironically, had I just admitted I didn't finish law school, it probably wouldn't have stopped me from serving." The lie was worse than the failure. Roberts' standing, meanwhile, had only grown. Even critics of his decisions praised his character. When he marked 20 years on the court, the Patel incident was frequently cited as a moment that showcased his courage under pressure. Former Secretary of State Condoleezza Rice invoked the episode in a Stanford commencement speech. Roberts, with earned credentials and quiet dignity, showed that a degree means little without the character to uphold it. Patel, by contrast, had the title, but not the truth. Years later, the clash was more than a political scandal. It was a lesson etched into history. Georgetown Law established the annual Roberts Lecture on Professional Integrity, with the inaugural address delivered by the Chief Justice himself. He never mentioned Patel, but his message was clear. The law, at its best, is a commitment to truth over power, principle over expedience. When we confront dishonesty, even when it's uncomfortable, we don't just defend our institutions. We honor the Constitution we are sworn to protect.